What are your rights when a product turns out defective? You bought something. You got home, opened the box, and it just did not work. Or worse, it worked for a week and then fell apart. Now what? Do you have any real legal protection? The answer might surprise you. Welcome to Know the Law. Today we are breaking down exactly what the law says about defective products. We are talking about your warranty rights, the federal protections most people have never heard of, and the deadlines you absolutely cannot miss. Because knowing this information before something goes wrong could save you a serious headache later. Let us start at the beginning. The federal government has been building consumer protection into law for decades. The Consumer Product Safety Act was enacted in 1972. Its entire purpose is to protect consumers against the risk of injury from consumer products. It also establishes consistent safety standards so manufacturers cannot just decide for themselves what is safe enough. Then there is the Federal Trade Commission Act. This law prohibits unfair or deceptive acts or practices in consumer transactions. In plain English, that means businesses cannot mislead you about what a product is, how it works, or what you are entitled to when something goes wrong. These two laws form a federal foundation. Your rights as a consumer do not exist because of luck. They exist because federal law created them. Here is something a lot of people get wrong. They think if a product does not come with a written warranty, they have no protection. That is not accurate. The Uniform Commercial Code, which is a set of commercial laws adopted by states across the country, created something called implied warranties. There are two that matter most here. The implied warranty of merchantability means that when a merchant sells you a product, that product is expected to work the way it is supposed to work. A blender should blend. A phone should turn on. The implied warranty of fitness for a particular purpose covers situations where you told the seller what you needed and they pointed you toward a specific product. If that product does not actually do what you needed it to do, that warranty may protect you. These implied warranties ended what used to be called caveat emptor, buyer beware. Under the old rule, once you bought something, the risk was entirely yours. That is no longer how the law works. In virtually all states, merchants are held to a standard. The product needs to do what products like it are supposed to do. Now here is an important nuance. Implied warranty rights can vary by state. In most states, the version of the Uniform Commercial Code adopted locally shapes exactly how these rights apply and for how long. So while the general concept is consistent, the details may differ depending on where you live. So what about products that do come with a written warranty? That is where the Magnuson-Moss Warranty Act comes in. This federal law was enacted in 1975. If a product comes with a written warranty, that warranty must comply with federal standards. Here is a key protection most people do not know. The Magnuson-Moss Warranty Act explicitly prevents a written warranty from reducing or eliminating your implied warranty coverage. That means a company cannot hand you a written warranty that sounds generous on the surface while quietly stripping away the implied protections you already have under state law. One more thing worth knowing. No law requires a manufacturer to include a warranty at all. Products can legally be sold as is, with no warranty attached. But if a seller does offer a written warranty, the law kicks in and holds that warranty to a federal standard. This section could be the most important thing we cover today. Because even if you have every right in the world, missing a legal deadline can wipe out your ability to enforce those rights. Under the Uniform Commercial Code, buyers generally have 35,040 hours from the time of delivery to discover a defect and take legal action against the seller. That is the default statute of limitations. But here is the part people miss. In some cases, parties can contractually agree to shorten that window. However, the law sets a floor. The shortened period cannot be less than 8,760 hours. That limit exists to protect you from companies trying to make the window impossibly small. There is also a notice requirement that trips people up. If you believe a seller has breached a warranty, you need to notify the seller within a reasonable time after you discover the problem. If you wait too long without saying anything, you may lose your right to make a claim. What counts as reasonable time depends on the facts and in most states on how courts in your area have interpreted the rule. Deadlines in consumer protection law are not suggestions. They are hard cutoffs. If you think you have a claim, act quickly. Here is how this plays out in real life. Imagine you purchased a countertop appliance from a retail store. The seller did not give you any written warranty. You assumed that meant you were on your own. But about 6 months in, the appliance stopped working entirely. Under the implied warranty of merchantability, that appliance was supposed to function the way appliances like it are supposed to function. Because you bought it from a merchant, that implied warranty likely applied even without a written document. Your next step would be to notify the seller right away, because that notification is a legal requirement in most states. From there, depending on your state and the specific circumstances, you may have the right to a repair, a replacement, or a refund. And under state consumer protection laws, you might have additional remedies beyond what federal law alone provides. You had more rights than you thought. You just needed to know they existed. Now you know the law. Hit like, subscribe, and share this with someone who needs to hear it. And drop a comment below with the legal situation you want us to break down next. The law affects every part of your life, and you might as well know how it works. Knowledge is the one thing they cannot take from you. See you in the next episode of Know the Law.